Be ready for the dictation. 5 seconds to go. The petitioner prays for issuance of writ in the nature of certiorari for quashing the notification bearing memo number 1258, whereby the petitioner has been put under suspension in exercise of powers vested under Rule 9 of the Government Servants Classification, Control and Appeal Rules 2005. The petitioner has also questioned the so-called notice bearing number 1358 of the Joint Secretary Sugarcane Industries Department impugned at Annexure 11, whereby the Joint Secretary purportedly, while issuing a note, has put the petitioner on notice requiring his reply within 15 days of the date of issuance thereof. Learned Counsel has referred to an inquiry report which was submitted following the initiation of inquiry against the petitioner on alleged charge of demand of bribe. While the resolution at Annexure 2 initiates a proceeding against the petitioner, Annexure 3 is the inquiry report so submitted by the inquiry officer cum joint director Sugarcane Department, whereby the petitioner has been exonerated of the charges. A decision was taken at the level of the department to await the disposal of the criminal case instituted against the petitioner in view of the inquiry report submitted as manifest from Annexure 4, which is stated to be the noting of the principal secretary. Nothing happened thereafter for 4 years until wide notification bearing number 322, the complete copy of which is enclosed at Annexure 12. The petitioner was put under suspension under Rule 9 of the rules. The suspension under order also followed a resolution whereby proceedings were initiated against the petitioner, a copy of which is enclosed at Annexure 6. The petitioner questioned the order of suspension as well as the resolution in CWJC number 9369 of 2014, and vide an order, the bench of this court stayed the departmental proceedings. The matter was finally heard and the order of suspension together with the resolution were quashed. I am extremely glad to be present here at the valedictory session of the Platinum Jubilee celebrations of Income Tax Appellate Tribunal. The tribunal, which was set up in 1941 to function as an impartial quasi-judicial body to resolve the disputes between the revenue and tax-paying public, is completing 75 years now. The concept of tribunals has been borrowed from the French judicial system, which had a set of administrative courts that ran parallel to the civil courts. The intention behind this system was to ease the civil courts from administrative matters while laying separate standards for administrative disputes. The modern Indian Republic was born as a welfare state, and thus the burden on the government to provide a host of welfare services to the people was immense. The quasi-judicial powers acquired by the administration led to a huge number of cases with respect to the manner in which these administrative bodies arrived at their decisions. The vast number of welfare legislations, coupled with the right to judicial review, was thought to burden the civil courts with more matters than they would be able to handle. Thus, various tribunals for income tax matters, railway rates, labor matters, and company courts were given statutory legitimacy to function parallel to ordinary civil courts.